Okay, we might kick off again. My name's Britta Jones. I'm the Chief Scientist with RSPCA Australia, and I'll be chairing this next session. It's my great pleasure to introduce Jed Goodfellow to give the next talk. Jed isn't just only a PhD candidate at Macquarie Uni, but he's also a member of my team with RSPCA Australia, and he's done an immense amount of work to get this day together. So we're really grateful for the work that he's put in and the success of the presentations today. So Jed will be talking to you this morning about the story of farm animal welfare regulation in Australia, captured by design.
Thank you, Britta. So my presentation really is on one aspect of my doctoral research at Macquarie University. And I'm going to have to run through fairly quickly, but all of these slides are going to be available online at a later date. So if I do go through the slides fairly quickly, don't worry, they'll be available for future use. So just very briefly, the structure that I'm addressing today, I'm going to give you a bit of a background as to the approach that I'm taking, why I think this approach is important. I'll introduce you to the concept of regulatory capture, and then I'll engage in applying that theory to the farm animal welfare regulatory framework in Australia. That will require an analysis of the competing interests that are at play within this field, and the design of the institutions involved with regulating farm animal welfare, and also a topic I think is very important, and that's nutting out the relationship between animal welfare and productivity. I think that's very important that we unpack that relationship and get a clear view of how it does interact. Then I'll have a quick overview of what I believe are the effects of regulatory capture, and finalise very briefly again with possible options for reforming the design of the regulatory framework. And I'm hoping that although I'm not going into the actual aspects of regulatory failure that I think exist within the current framework, Elizabeth certainly gave us an introduction to perhaps some of those failures. But I would like to just outline two aspects, and also Philip's presentation did touch on these aspects as well, and that is the significant disparity between what we state in animal welfare policy and what occurs in practice and what is written in our statutes in relation to animal welfare. On the one hand, in policy, and I'm talking about the Australian Animal Welfare Strategy, we recognise animals as sentient beings with intrinsic value. Yet, in reality, the way we treat animals, particularly in farming environments, doesn't reflect that recognition whatsoever. And likewise, the disparity between community expectations in relation to how animals should be treated and the reality of that treatment in practice is even greater still. And I would suggest that this is a very unsustainable place to be in for farm animal welfare policy, and it will lead to further conflict in the future between agricultural industries and the broader Australian community. As Philip mentioned also, this is not just a concern of the animal welfare lobby, even though the animal welfare lobby, of course, is the sort of leader in the debate, but it is a concern of the broader Australian community now. It's become very mainstream. My concern is that the current governance and regulatory systems that we have in place, the design of those systems will not be effective in closing that gap, bridging the disparity. And I think in animal law scholarship there needs to be a greater focus on the machinery of government, applying scrutiny to the processes, the frameworks and the design of the institutions, rather than just focusing on the outcomes of what I believe is a flawed system. So regulatory capture theory, it's a theory of regulatory law. Essentially, in very broad terms, it relates to the private distortion of public purposes. So it occurs when a regulatory agency acts in the interests of the industry or the individual or the firm that it is regulating in a way that is inconsistent with the public interest that is supposed to be served by the regulation. So it's a form of undue influence, if you like. And there are many different conceptions of regulatory capture. It will depend upon at what level it occurs at, whether it's at the political level, the agency level, or the individual inspector level, and what functions it affects. But also the actions of the regulatee, being the industry, will determine what form of capture and how it manifests itself. And there are hard and soft forms of capture. Hard forms of capture may describe a form of aggressive industry lobbying where government is captured by the interests of industry in a deliberate sense. It may include favours to government, it may include bribes, and then you get into the realm of corruption. On the other side of the spectrum, you have soft forms of capture where we're talking about legitimate actions on behalf of industry, so in terms of normal communications with government, but there is still a capture of interests in the sense that there is an alignment of normative conceptions or an alignment of cultures between the regulator and the regulatee in a way that is inconsistent with the public interest that underpins the statute. So that's just a broad background of capture. So these are the conclusions that I'm making. I want to put my conclusions first and then go into the analysis. I believe that there is regulatory capture throughout the farm animal welfare regulatory framework, at the political level through SCOPE, and at the agency level through the Departments of Primary Industries and Agriculture. And I believe the capture affects both the standard-setting functions of government in terms of the development of laws and also the enforcement functions as well. But what I'm suggesting in relation to the cause of the capture is that it is caused by the design of the framework. So I'm not alleging here that there's any untoward actions on behalf of industry in terms of its relationship with government. And likewise, I'm not alleging any kind of failure on behalf of the government personnel within the departments. What I'm focusing my criticism on is the design of the framework. And I would suggest that there may be a form of deep capture or cultural capture in this sense due to the design framework, but that will require further empirical research that I'm not intending to do within my doctoral thesis. So an analysis of capture requires an assessment of the competing responsibilities within the departments that are responsible for administering the legislation and the interests that underpin those competing responsibilities. So by responsible institutions, I'm talking about SCOPE and I'm talking about the Departments of Agriculture and Primary Industries at the state and the federal level. So of course, these are the responsible institutions. You'll see that in ACT, Northern Territory and South Australia, it's not the DPI that has the primary administrative functions there. However, the primary industries ministers, the agricultural ministers there still sit on the SCOPE and they still have representatives within the National Animal Welfare Committee, which is an intergovernmental committee that decides matters of animal welfare policy. So they're still prevalent in setting the policy agenda in those jurisdictions. So this is just a snapshot to try and demonstrate the role, the responsibility of these institutions. And it's certainly not surprising, and I don't think anyone would debate me, that these are representational samples of mission statements in relation to what the objectives are of these organisations. So it's very much about promoting profitable primary industries, productive primary industries, and also sustainable primary industries, as Philip mentioned. And the same focus is certainly within the national bodies that we're seeing. So another focus on productive primary industries, which of course is perfectly legitimate. There's no criticism of that role and that responsibility on behalf of Departments of Agriculture. Of course, that is their function. They're there to serve the interests of the agricultural communities in order to ensure productive primary industries, and that is in the public interest. The real question is whether or not these same institutions should also have the responsibility for protecting and promoting farm animal welfare. So that's what I want to talk about now. So this requires, in order to answer that question, it requires a consideration of the nature of the relationship between animal welfare and productivity. Are these interests in conflict, or are they mutually beneficial? And we see an enormous amount of simplification, especially in the public debate, in relation to the relationship between these two issues. We hear time and time again statements to the following, that my animals are happy and therefore, or my animals are productive, for instance, or other husbandry procedures that are undertaken with no form of pain relief. Generally, members of the community who are not otherwise aware of those procedures, when they're made aware of those procedures, there is quite a bit of shock and concern that actually takes place. So I don't have any empirical evidence to show definitively that the extent of that disparity, but I certainly believe that it does exist. But it is a topic for further research, I think.
Jed, I think my point is that those procedures are adequately and well described in those regulatory instruments.
The disparity that I was talking about was between community expectations and the reality of what occurs in practice, including what is written in our standards and guidelines. So my view is that the community doesn't have a great deal of awareness or knowledge about the reality of what occurs in practice. So yeah, I think we're getting a bit confused about what I think is where I think the gap is. So I agree that the legislation does reflect what happens in reality, but that's not the disparity that I'm talking about. I'm talking about community expectations and standards in law.
We've got time for one more, just behind you at the back.
Mary Bennett, Department of Primary Industries in Tasmania. Just on that point, I just wonder if some evidence does exist, given that we saw the Model Code of Practice for Pigs, which was agreed in 2007, that agreed one position with regard to sow stalls, that we would reduce use to 6 weeks per gestation in 2017. I would suggest that maybe it didn't reflect where community sentiment was at, given that we saw the industry voluntarily decide to change that. And they've actually announced that they're voluntarily going to move away from sow stall use during gestation by 2017. That would suggest to me that perhaps when the Model Code of Practice was developed, it didn't quite read where the public was at.
Well, that supports what I'm referring to as the disparity between community expectations and what is written in our standards and guidelines. So, the fact that the pork industry has taken it upon itself to go beyond what is required by law, as Philip said, that is a requirement of industry in order to maintain its social licence. I think the pork industry should be applauded for doing so.
Yeah, we're recognising that point, but obviously that didn't happen at the time.
The
Model Code was actually
that's right.
negotiated.
So that's a failing, in my view, of the standard setting process.
Yes.
It doesn't reflect community expectations, but I understand the competing interests that are involved, but I think there needs to be a more objective framework for developing those standards, and that was the nature of my conclusion.
Okay, thank you very much, Jed.